Hi, I'm Mirriam, and this is Trials and Errors, a show where we demystify the workings of the justice system so you can fight those Twitter trolls and those Facebook fanatics. Today, I'm going to be making hot chocolate and talking about bail. And in particular, we're going to talk about the Capitol Hill seditionists and why some of them did get bail and some did not. Let's go. A few days ago, I did a live stream when the guy that they call the Q Shaman, Jake Agneli, had his detention hearing. So right before then, I did a live stream to kind of explain federal bail hearings and how they are conducted, what judges look for. My opinion as a criminal defense attorney is that he should have been released. Here was a guy with no prior criminal record, no contacts with the criminal justice system. He had a spear type thing, but no weapons, and he was detained. So I want to just say something before I continue this talk, because I'm going to say some things that may misconstrue how I feel about bail and pretrial detention and about jails in particular. I'm an abolitionist. I think we can imagine a world where we actually don't put people in cages, whether before trial or after trial. I think that there are forms of punishment, rehabilitation, etc., that we can create that will actually meet the ends of actual justice. What we have in place instead is a carceral system. And the easiest thing to do is to put people in a cage instead of trying to devise methods or means of making sure that people who have broken the law don't break the law again. What's interesting about the federal bail system, and I want to make a distinction, we're not talking about a state court. And that's important because each state has its own way of setting bond or bail. Some states have done away with cash bail. Each state has its own list of criteria for determining how someone gets released or what they need to look for in order to release someone before trial. The other thing that's really interesting is that we have this whole innocent until proven guilty thing. Yet, we allow you to sit in jail for as long as it takes before you go to trial. Innocent until proven guilty is a legal fiction. It is actually just a myth that's created when you go to trial in front of a jury. Because, let's be honest, you think a judge is going to allow someone to sit in jail for a year, maybe two, until trial, if they think they're actually innocent? Now, in the federal system, and again, you can click on the link below and watch the live stream, which gets you a lot more detail. In the federal system, what you are looking for is to get someone released. In the federal system, the federal statute, the Bail Reform Act, actually says the first thing you think about doing is releasing someone. That's first, and not releasing them with an ankle monitor or into the custody of someone else or anything like that. Just release them. Bye. See you later. Here's your next court date. Or what's called a personal recognizance bond. And what that is a piece of paper that says, I promise if I don't show up for court, I'm going to pay X amount of money. No cash bail. After that, you have what's called orders and conditions. What are the least onerous orders and conditions? What can we do to make sure that you're not a flight risk and or you're not a risk of safety to the community? In the Q Shaman case, he was held without bond. The judge had said there were no orders and conditions that could be fashioned to make sure that he would show up for court and that he was a risk of danger to the community. I don't think the judge was wrong, although I think that he had a lot of factors in favor of release. On Friday, a different judge in a different jurisdiction in Tennessee actually decided that the zip tie guy, his name is Eric Munchel, could be released. And it was a really odd decision considering the fact that Mr. Munchel had a cache of weapons, was on video, and it turns out he's actually been arrested before, has been convicted of crimes before, and has a failure to appear. So when you look at these two things, you're like, what happened? What could be the difference here? The real issue is the difference is just in a matter of who the judge is. We all know in our jurisdiction the judges that are more inclined to release and the judges that aren't. And this judge clearly is one who follows the Bail Reform Act and decided that this guy should be released. Now, before I go on, I want to talk about the charges against Jake Agneli versus Munchel. And Mr. Agneli was charged on his own, and Munchel is charged with his mother in a conspiracy. And if you click on the link below, I have a video about what is federal conspiracy that you can learn about as well. Now, one of the things that I think a lot of people are asking is, why is this not charged? Why isn't everyone charged with conspiracy? And why aren't the people at the very tippy top charged with conspiracy? The people who incited the riot, the people who said, go and fight for your country. This is a trial by combat. I think prosecutors are a funny breed, and especially in federal court, they will frequently undercharge initially to hold back some of their evidence. They continue to investigate even when these cases are ongoing. So what can happen is you get charged with something that's fairly low level, you are either held or you're released, and then in a couple of months they get more evidence because the investigation is ongoing, and you get charged with something new in what's called a superseding indictment. And prosecutors don't want to tell you everything they have. So it's very possible that right now what we're seeing is just the tip of the iceberg. It may be all they have. If you think something is undercharged at the front end, if you think, well, they're only charged with trespass, or they're only charged with, conspiring to trespass, you can just wait and see what happens. On Friday, Mr. Munchel was released by the magistrate judge. And today, after an appeal by the government to a DC district court judge, he's held. Why the difference? I didn't get to see what happened in court, but I did read the government's appeal to the DC district, and it lays it out pretty clearly. Mr. Munchel's weapons were legal in Tennessee. That's great. But if he's allowed to have weapons in Tennessee, he can go back to Tennessee and just get more weapons. There's nothing to prevent him, even if this judge took his weapons. Nothing to say he can't get new ones. There's nothing to prevent him from traveling other than the judges say so. And we can see that he's not about to follow the law, especially since he has a prior FTA. Mr. Munchel wasn't going to be released until Monday anyway. And so what the government did was they asked for a stay, which was granted by the district court in DC until he can have a detention hearing. So Mr. Munchel will have a hearing in DC district court in front of a DC district court judge. And I'm guessing it's going to go a little bit differently for him this time. A lot of these seditionists were actually released, and the government didn't file an appeal. But if they're recharged, if they're charged with something else, they can be brought back in. You can have a new bond hearing because you have a change in circumstances, and then they can be held. What I want to make clear, though, is that new charges and new evidence of those crimes is only half of what a judge has to consider when talking about release on bail in federal court. ostensibly, we would think that who the person is, their background, their characteristics, that part doesn't change. But what could change is if the investigation leads to other information. For example, if they happen to mislead the court or investigators, that would be a change in who they are and their background and characteristics. Or if, as they go through this investigation, they find out that they were part of, I don't know, the Oath Keepers, for example, or some other sort of group that has been designated as a domestic terrorist organization. So all of those things could be different because remember, a lot of these people did speak with the police. They did speak with the federal investigators and they gave them information. So if that information is different, that can be a reason why they should be held. I don't agree with holding people pre-trial, but we have the laws that we have. And the reality is my clients would be held 100 times out of 100 if they drove from Tennessee to Washington, D.C. with a stash of weapons and then broke into the Capitol with a taser, grabbed a bunch of zip ties, and went into the Senate chamber. That's just the truth. Do I want these people to have the same outcome as my clients? Emotionally, yeah, I do. I want the law to be applied fairly. And if these people are released while our clients are held, it's not fair. This would be an error of the criminal justice system to not hold certain people accountable, but hold other people accountable. If you like this video, please subscribe to our channel. The more subscribers we have, the more likely it is we can get into the algorithm. And remember, the way to beat disinformation is with real information.